What is judicial review? As you already know, the government has three branches: the legislative, the executive, and the judiciary. The legislative makes the law, the executive implements the law, and the judiciary resolves any disputes and also interprets the law. The constitutional framework ensures that there is a separation of powers and functions between these three branches of the government. There is also a system of checks and balances to ensure that the different branches of the government are accountable for their actions. And the misuse or the misapplication of powers can be reviewed by the other branches. On the subject of laws, the legislative makes the law, the executive applies the law. But what if the legislative has made a law that is violating the constitution, or the law is going against the principles of natural justice? Or what if the law is good, but the way the executive is applying the law is not correct? Or what if the executive is misinterpreting, misapplying, or misusing the law? This is where the judiciary can come in and review the law and also review the application of the law. And this review is nothing but judicial review. The concept of judicial review is built into the Indian Constitution. Article 13(2) says that the state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of the contravention, be void. In simple words, the Constitution says that the state shall not make any laws that violate the Constitution. Now, what is this state? The state includes all the three branches of the government: the legislative, the executive, and the judiciary, because all the three branches are involved in the process of making laws. The legislative makes statutes or acts and can also amend the constitution itself. The executive will use the powers conferred by these statutes or acts and make various rules, bylaws, ordinances, regulations, and also undertakes actions to implement the law. And the judiciary passes various judgments, orders, decrees, and injunctions, all of which are also laws, like case laws. If any of these laws or actions by any of these three branches of the government are violating the Constitution or the principles of natural justice, then the judiciary can review them. The Constitution also supports the process of judicial review through several articles. Under Article 136, the Supreme Court can allow the appeal of any judgment, decree, determination, sentence, or order in any cause or matter passed by any court or tribunal, including those passed by the Supreme Court itself, which means that the Supreme Court has the power to review any judgments or any actions even by the Supreme Court itself. Under Article 32, the Supreme Court can issue writs like habeas corpus to protect various fundamental rights. And Article 226 empowers the High Courts with a similar writ jurisdiction as the Supreme Court, but within their own respective jurisdiction, which is usually the state where the High Court is located. And in various landmark judgments, the Supreme Court has held that this concept of judicial review is a part of the basic structure of the Constitution itself, and the legislature cannot amend the Constitution to take away this process of judicial review.